not constitute, and then he goes on to say, does not constitute a marketable value of the business. Well, that does, Your Honor. That is the value of the business, is his brain and his marketing. And this is his sole support and has been for decades for his family of 9. So I think it's very relevant because it is a marital property.
Right. That's my point, is there's no value to it.
Well, okay, she can take the business, but she's not the business. She can't do anything with the business other than possibly sell it. But the worth is in Mr. Joseph's mind and his ability to work.
What she's essentially asking is to value Mr. Joseph as though he himself is the asset. She said that the value is him. He's not an asset, he's the person.
This is where it gets absurd. She's literally asking the court to treat her ex-husband's brain as a marital asset. Forget the house, the car, the furniture. She wants half of his thoughts. That's not how divorce works.
I'm going to take up the motion for business valuation first because it's pretty short and sweet and to the point. Mr. Joseph has run his, I think it's Joseph Tech, for at least the last couple of decades, and he has obviously built up some goodwill and some a marketplace for his business, and they have valued it for just the physical assets, and they have not taken into account, even though Mr. Andrews in his response said that it's exclusively the product of petitioner's knowledge and labor, which does not constitute, and then he goes on to say, does not constitute a marketable value of the business. Well, that does, Your Honor. That is the value of the business, is his brain and his marketing. And this is his sole support and has been for decades for his family of 9. So I think it's very relevant because it is a marital property.
Here's the strategy. They're trying to inflate the business by pretending his skills are property. But the only real assets are a couple computers worth $2,600. No judge in their right mind should call a brain business goodwill.
For us to get a good valuation of what this business, how much this business is worth, so we can divide the marital estate. Because until we have a good valuation, I can't advise my client on, an equitable and just and fair settlement. So that's why I would ask the judge to allow us to have a business valuation. And I do have 2 possible persons that we could have appointed. And yes, I did ask that the business take on that because, and in my opinion, it's because they have skirted the value and not given a reasonable value. And because of that, I had to A, file the motion, and B, we're having to do the business valuation. So yes, I think the business should pay for the business valuation. And I ask that the judge grant my motion. I think the value of the business is much more than just the value of the computer equipment he has, that he values at $2,600.
Brilliant move. He basically says, fine, if it's worth so much, you can have it. And of course, they refuse because they know it's worthless without him. That's the checkmate moment.
Your Honor, my position is that my client's essentially a contractor. He, and I think he almost exclusively works for just one client, one customer, if you will, but he does computer repair. There's no real goodwill in the sense that he could market himself in some way that would allow him to have value other than just simply being able to do the job like any other computer technician is able to do the job. Our position isn't necessarily that we're opposed to a business valuation. It was that we are opposed. We are frustrated that how many years later, we're now asking for a business valuation in this case. So the delay is frustrating, but the biggest source of our objection is this idea that the business should pay for it. And there is no business separate from Mr. Joseph. So what they're really asking is for Mr. Joseph to pay for it. They had a business valuation that was, in my opinion, ridiculous. And that was essentially their position was we were being unreasonable by not agreeing to it. And we flat out said, if you think the business is worth that much, we will happily award you the business. You can have Joseph Tech, the name, any goodwill built from it, and you could just pay that value. But they're not willing to do that because they know there's no value to it.
Exactly. You can transfer a company name, but you can't transfer someone's talent. If she takes it, it's like buying a restaurant, but leaving the chef behind. Good luck running it.
And so this is just meant to try to further harass and delay, incur additional fees for Mr. Joseph out of his pocket, in an effort to essentially somehow, I don't know why, other than just spite, punishment, leverage, but there's no legitimate reason that somebody who works for themselves as a sole proprietor doing computer tech needs to have a full business valuation. This is something that he does out of his home on his computer. We listed the computer as a business asset, but there's nothing special about it. It's a computer. And if they want to pursue a business valuation, we're happy to make Mr. Joseph's happy to make himself and anything they need available to the valuator. But the idea is that they don't really want the business valuation. They want him to pay for it. And if they truly wanted it, they would get it themselves, but they don't want to because there's not really any purpose other than delay. That's our position. And I don't think that this is a situation where goodwill really applies. I mean, if this was something where Mr. Joseph was selling the business and entering into a non-compete clause, then there could be some generated goodwill that could have value, but that's not the situation here. They're just simply seeking to try to manufacture an asset out of thin air. And
then out of nowhere, the judge brings up AI to explain goodwill. Yep, we've officially reached the point where divorce court is citing artificial intelligence to settle who owns a man's brain. I did not have that on my 2025 bingo card.
Or equipment owned by the business.
Well, again, I've had a couple of cases go to trial that were highly frustrating, truthfully, because no one wanted to pay. Well, one was the house that was kind of a ranch. The other was an operation of a ranching business, neither of which were valued by any expert. But yet they didn't agree on the value of anything within the business. So it's like, if you're not, one person thought a horse was worth $50,000 and the other said it was worth $5,000. And so I was constantly in the trial going through trying to ascertain the value of things when I'm no expert and they weren't even close in terms of the value of if you just rely on assets within the business.
Well, and I guess our position, Your Honor, is that we can make it easy. We will award the business to Ms. Joseph at their value.
Your Honor, may I respond?
But that kind of proves their point, which is she could take the business but do nothing with it to generate income.
Right. That's my point. There's no value to it.
Well, okay, she can take the business, but she's not the business. She can't do anything with the business other than possibly sell it.
In the end, the case drags on, but honestly, it should have been dismissed on day one. A person's mind, skills, and knowledge aren't assets you can divide in a divorce. The fact this even made it to court is wild.
To delay and to harass. I am not. I'm doing this.
No, I think honestly,
and to give this to you and say, here, Judge, this is the value of what we're talking about.
I understand. I don't think he was suggesting that you're trying to delay and harass. He said they're just frustrated with it because this has been ongoing for a very long time. This is a very old case.
And I would like I would like to get it over with, Your Honor, as well. And if the sticking point is paying for it, we would agree to split the cost of the valuation because it benefits both parties.
We disagree that it benefits us in any way to have a valuation that's going to prove what we've said, that there's no value to this. What she's essentially asking is to value Mr. Joseph as though he himself is the asset. She said that the value is him. He's not an asset, he's the person. There may be some validity there based on his earning capacity and past earning potential. But to assign a value to him for earning income is no different from saying that somebody who works and receives a salary should be valued for their salary because they bring in an income. That's not an asset to value. That's just income. This is not a marketable asset.
That was well articulated, and I don't understand why this is still even up for discussion. How can someone's ability to earn be considered an asset? That's simply not how it works, and they know it. He explained it perfectly. They might have a point if they were using that figure to calculate things like income for support or benefits, but treating it as an asset is absolutely insane.
So it does have value. And this is how he has made his living, supporting, there's the word I was looking for, supporting his family of 9 for decades. And he may only have one client. I don't know, but certainly evaluation would help us. But
the word marketable implies it can be sold. And that's the whole point, is even, I believe, Ms. Adams concedes that this is not, any goodwill is not marketable. Otherwise, they would be accepting the asset to sell it, but they know that it's not marketable, which is why they don't want to accept the asset.
Okay, hang on. If you want to look at AI, it talks about differentiating personal versus enterprise goodwill. Personal goodwill, this is the intangible value tied to an individual's skills, reputation, and relationships within the business. Enterprise goodwill, this represents the value inherent in the business itself, brand, customer base, location, and is independent of the individual owner.
I've seen a lot of court cases and honestly thought nothing could surprise me anymore. But I was wrong. The judge completely caught me off guard when she brought AI into court. I never saw that coming. At this point, I think he should seriously consider finding another judge.
Mr. Andrews listed other debts, and that was the first I had seen those. And that was what I was trying to get information on.
But those are all debts that are only in her client's name.
Well, but you didn't tell me that.
But your client could have, I would have thought.
Your Honor, he's responsible for answering the questions. I mean, I don't get why I've had to ask 5 times for the same thing.